CPD for me. It's mandatory CPD, practical and relevant.
There's actually two particular opportunities for employees to cling on to statements that are made leading into the employment arrangement. And the first actually sits within the Australian consumer law, and it's actually clause 31, and it addresses specifically the statements that are made in relation to the nature of the terms and conditions of employment, or in fact any other matter addressing employment leading up to the person commencing. Now, there's indeed a separate obligation in relation to misleading in relation to workplace rights, which sits within the Fair Work Act. And the implications of those two obligations are very different, because in relation to the ACL, the claims based on Australian consumer law tend to focus very much upon the question of recovery. What was said, that I relied upon it. In relying upon it, what options did I then close myself off to take this position up, and what were the financial ramifications of that? In the Fair Work Act, where it addresses the issue of workplace rights and misleading someone about their workplace rights, that's a slightly different issue, because where the financial sting in that tends to be around the civil penalties that can follow, which can be considerable.